No, that's what I'm doing.
Because you've got your phone out, you're pointing your camera towards personal cars.
Taking pictures of the fence.
What?
I'm taking pictures of the fence.
Why are you doing it?
What's it got to do with you? Do you come round to the side?
No, right, well.
Alright.
What are you doing?
Taking pictures.
Of?
The fence.
The fence? Why?
I like fences.
Like fences?
I went to the reception, she said it's fine.
Right, it's not fine, is it really?
Is it not fine?
No. Current threat levels at the moment, isn't it, for the police, and you're filming private cars?
Can you draw a step back a bit?
No, not at all. What's your name, buddy?
I'm not telling you my name.
Not telling his name? Right.
You don't need to, but you just need to grow up a bit, don't you?
Really?
Yeah. Because all you're doing is just trying to antagonise people.
I'm not trying to antagonise anyone.
Yeah.
No, I'm not.
Yes, you are. You're still filming personal people's private cars.
I'm not filming the cars.
You sat there with you. I've just watched your screen. You're videoing.
I know I'm videoing.
Exactly.
But I'm taking pictures of the fence.
Yeah.
I went to reception. She said it's fine.
PC Morris immediately falls back on the familiar claim that you cannot film a police station because of current threat levels. But that argument ignores an important fact. There has not been a successful terrorist attack on a UK police station in more than a decade. Since 2010, none of the recorded terrorist plots involve someone standing outside a police station filming from a public pavement. In fact, guidance from police authorities makes it clear that photographing or filming police buildings is lawful and is not, by itself, grounds for suspicion. Every year, millions of people pass by and film police stations, including tourists, vloggers, and ordinary members of the public. Yet somehow, auditors are often treated as if they pose a serious security threat.
You're taking a piece of people's personal car
I'm not taking pictures of cars.
when the threat level is very high.
Even if I was taking pictures of cars,
Yeah.
is it against the law?
You can film. I'm just asking you why with the current threat level. What do you do for a living?
It's my own business.
Your child.
Am I a child?
Yeah. You act like an adult. Then.
Do you need retraining now to deal with the public?
No.
I think you do.
Not really.
What's up with you, mate?
What?
What's up with you?
Nothing.
You got a good photo there?
Video, mate, video.
Video. You do realise that without my permission as a police officer, you cannot use that video, and I can confiscate that as well if I need to.
I don't think so.
I do.
What law is that?
That'll be the law and the pace that I'm going to find out at this moment in time.
Alright, am I being detained?
At this moment in time, you are.
For what?
Well, I'm just going to get the code at this moment in time, and I'm going to search it under an act.
Alright, yeah.
And then you'll have to provide your details as well.
No, I don't.
Yes, you
No, I
do.
don't.
When you're detained, you do.
No, I don't.
Morris seems completely confused about the powers available to him. He confidently claims that FTA cannot use footage of him without permission and suggests that he can confiscate the footage if necessary. That is simply not true. There is no law in the UK that gives police officers ownership of footage recorded in public. Likewise, police cannot seize a camera unless it contains evidence relating to an actual offence. As Morris moves closer to FTA, he suddenly announces that he is being detained. When FTA asks the obvious question, under what power, Morris responds by saying he is going to get a code. That single moment sums up the entire incident. He has already restricted FTA's freedom without identifying any legal authority and is now waiting for a colleague to tell him which law might justify the detention.
Are you recording? You should inform me, shouldn't you?
It's there.
It's there. I know you got a camera, but I don't know it's on, do I? Until you inform me.
We're going to do that now. Alright then, at this moment in time, you're staying under Section 23 of the Terrorist Act, okay?
23?
Section 43 of the Terrorist Act.
43, right, yeah.
43 of the Terrorist Act. So basically, you're ballied up at this moment in time and you're taking personal videos of that, okay? So I'm going to ask you to remove that at this moment and give me your personal details.
Right, under Section 43, I don't have to give my details.
Well, you do at this moment in time. If your details provide out under this search at this moment in time, I'll just arrest you, mate.
For what?
For this moment in time, for a possible terrorist act.
So you think I'm a terrorist? I'm overt. I'm not covert.
Okay.
Have you read the memo
What memo?
on people filming around police stations?
I have.
Yeah?
A bit suspicious though, isn't it, pal?
No, it's not suspicious, because I've told you exactly what I'm doing.
You're not filming fences?
Yeah?
Why?
I like fences.
Why do you like fences?
Because that's what I'm into, that's what I do in my free time.
Where's your best fence then that you've had? Show me other videos then of your best fences.
I like police fences.
Like police fences?
Yeah, yeah.
Right, so that's a bit suspicious then, isn't it?
Oh, is it?
Right.
After receiving guidance over the radio, PC Morris finally names a power, but he still gets it wrong. He first mentions Section 23, which has nothing to do with terrorism and is not a detention power. When FTA questions him, Morris quickly switches to Section 43 of the Terrorism Act, making it clear that he never had a solid legal basis to begin with. Section 43 requires an officer to have reasonable suspicion that a specific individual is involved in terrorism. A person holding a camera does not automatically meet that threshold, nor does a general reference to current threat levels. The situation gets worse when Morris starts demanding FTA's personal details and threatens arrest if he refuses. That is not a simple mistake. It is a misunderstanding of the law. Under Section 43, officers may conduct a search, but they cannot force someone to identify themselves.
Okay, before I search then, you got anything that's going to harm you or me or any of my colleagues?
No.
Okay, do you want to take your hands out your pockets then for us?
Yep.
Make sure you get my good side.
Turn round.
Why's that?
Let's get your good side.
Good side's good side. Like, have we got two phones on you?
That one's for phoning, this one's for taking pictures.
Oh, you said he was videoing, not taking pictures?
Well, you can take stills of the videos, can't I?
Oh, I see. So you tried to correct me before, but you were wrong yourself, wasn't you?
I'm not wrong, am I?
Well, you was, wasn't you? That Jaguar key. You know what they say about people who drive Jaguars, don't you?
What's that?
Drive Jaguars. Alright, balls going between your legs, do not kick out, it'll be your... Right, I just think you should leave.
Can I put my stuff back in my pockets?
What's it's your stuff?
Yep.
Right, you've got another offence now, I think you should move on.
Once the search produces no evidence, PC Morris should be satisfied. The purpose of a Section 43 search is to confirm or remove suspicion. If nothing is found, the matter should be over. Instead, Morris continues treating FDA as if he remains a threat. He tells him that he should leave because he has filmed enough of the fence. That request is not based on safety or necessity. It appears to come from frustration rather than any genuine policing purpose. Even after the search confirms that FDA is carrying nothing suspicious, Morris still tries to push him away from an area where he is legally entitled to stand and film. A professional response would have been simple: the search is complete. You're free to go. Then walk away.
I walked on there.
Good, bye-bye.
Look at this fence, this is interesting. Just going to get all the fences as I walk down, is that alright?
Switch it off, mate, you don't need to.
You can't tell me to switch it off.
Oh, you're right, I can't, but just switch it off, isn't it?
And you never got me details, did you? Because you can't get me details. Under Section 43 you can't. Off you pop.
I'm just here with an update from the solicitors, who've basically confirmed that they've received a response from the defendant, which is the PC Morris, PC 16660 from Longside Police Station. They have rejected the Part 36 offer, and their stance on liability has not changed. And the only way to progress is to issue court proceedings.
This letter from FDA solicitors reveals more than it may seem at first glance. When a claimant's legal team states that the defendant has rejected a Part 36 offer, it usually means the other side has decided to fight the claim rather than settle early. Part 36 offers exist to give parties an opportunity to resolve disputes before legal costs increase. By rejecting the offer, the force risked turning a relatively inexpensive settlement into a much more costly legal battle. In a case involving allegations of an unlawful stop, detention, and search, the decision may have encouraged FDA's legal team to continue pursuing the claim.
They are of the professional opinion that there are reasonable prospects of success to issue court proceedings. The following reasons are: it is not a criminal offence to record a police officer or police station, and this in itself is not enough to satisfy honest and reasonable suspicion that I am a terrorist or engaging in terrorist activity. In their view, they are under no legal obligation to provide details to PC Morris. Even if a court finds that my detainment and search was lawful, PC Morris failed to provide the necessary information prior to the search. This is his name and the police station to which he is attached, which could render the lawful search unlawful.
In the end, every legal justification for this detention appears to fall apart. When a solicitor openly states that there are reasonable prospects of success and suggests that procedural failures may have rendered the search unlawful, it is a strong indication that the force faces significant legal difficulties. FDA later appeared to confirm the outcome himself. When a viewer suggested that he should sue, he replied, "I did and I've been paid out." That response provides a fitting conclusion to the story. The solicitor outlined why the claim had strong prospects, and FDA later indicated that the case ended successfully in his favor. It is another example of officers relying on powers they either misunderstood or could not properly justify, only for the entire incident to be captured on camera. That's all for today's video. If you enjoyed this episode, please like, comment, and subscribe. Your support helps me continue producing independent coverage. Also, be sure to check out Free Time's audits. You'll find a link to his channel in the description. Show him some support. Thanks for watching.